B, protection against torture, inhuman or degrading treatment or punishment, is rather like Article 3 of the European Convention on Human Rights, which, at least since 1989, has, with the case of Surin, has been interpreted at European level to prevent the expulsion of someone facing torture or inhuman or degrading treatment or punishment in their destination of expulsion. But 15C is a new creature without precedent, perhaps, in international law in some senses. And when one looks at it, it's a phrase which is not particularly lucid in terms of its meaning. Its requirements are a serious individual threat to a civilian's life or person by reason of indiscriminate violence in situations of armed conflict. So you need to have something that's individualised and also something that's indiscriminate. A machine gun with a blindfold shooting bullets with your name on it. And the Home Office certainly, I think, have hidden behind the fairly unclear Delphic terms of that provision to try and suggest that there is no new form of protection intended by 15C. The Home Office position, which they put up quite quickly on amongst their asylum policy instructions, was that Article 15C was no more than a reminder to the forgetful decision maker, be they judge or administrator, that merely because this country was in a state of war, you could still win an Article 3 case or an Article 2 case, as it were. That's to say that simply because somewhere was in a state of war rather than peace, people who feared death penalty, execution, torture, inhuman degrading treatment or punishment could still gain protection, notwithstanding that some people would say that human rights law doesn't run fully in times of armed conflict, itself a moot point. The bare text of the article, I suspect, doesn't really bear too much analysis without looking at some other sources in order to try and cast light at what the European community might have been trying to get at when it was producing this document. And so what were their intentions? The drafting history kicks off with various proclamations by European bodies, especially the European Commission, of their broad aspirations, and heavily supported by bodies that might be thought to have a weighty interest in the matter, like the United Nations High Commissioner for Refugees, UNHCR. And they were very keen to emphasise that this provision was part of a broader protection regime in Europe, not to be read simply as one little feature of one article in the Refugee Qualification Directive, but rather a piece in a broader jigsaw. And the jigsaw into which it most obviously fitted was the link to the Temporary Protection Directive, which was written, I think, in 2001 and entered force probably in 2003. The Temporary Protection Directive was brought into force in order to deal with the aftermath of the Yugoslavian difficulties. And obviously the Balkans in the early 90s were riven by the most serious civil war to strike Europe for a very long time. And it caused a mass influx of individuals over the borders. And some parts of Europe obviously took more than what they thought was their fair share, especially Italy, I guess. And the Temporary Protection Directive basically says that where you have a mass influx of people in danger from certain forms of harm, the European Council may choose to declare there to be a mass influx, and those people should be given temporary protection to avoid having to go through all the thousands of individual cases in order to determine whether or not individually they are refugees or face Article 2 or Article 3 human rights breaches. But the Temporary Protection Directive is by no means coordinate in territory with Article 15C. So the Temporary Protection Directive is expressed in terms, I've already said, of mass influx, and is a lot broader. It also talks about mass violations of human rights, I think the phrase is, a lot broader than 15C, which only talks about these risks to life or person fleeing from armed conflicts. And it seems that the happy link between the Temporary Protection Directive and the Refugee Qualification Directive was broken in the drafting history, because once the European Commission proposal went into the negotiation stage and went into the European Council, member states whittled down the protection offered very significantly, and whereas the original terms of Article 15C pretty well mirrored the terms of the Temporary Protection Directive, when it came out the other end of the drafting sausage machine, it simply referred to people fearing threats to their life or person from armed conflicts. So there's a link with the Temporary Protection Directive, but not one that doesn't really solve all the interpretive problems that the provision puts in our way. What help then do we get from other interpretive sources? One big issue is the question of intention. Where better to find the intention of this provision than the preamble of the directive itself? And the preamble, paragraph 1 of the preamble, which is on the first page of the next cabinet, says that the common policy of asylum, including a common European asylum system, is a constituent part of the European Union's objective of progressively establishing an area of freedom, security and justice open to those who, forced by circumstances, legitimately seek protection in the community. A pretty interesting language there. An area of freedom, security and justice open to those who, forced by circumstances, legitimately seek protection in the community. There you see, forced by circumstances, something that is very reminiscent, I would suggest, of what the Temporary Protection Directive was talking about, when it was talking about mass violations of human rights as well as protecting the victims of armed conflict. And it does seem that the preambular intention of this directive, whatever the narrow terms which provide its actual text later on, was very broad. Those forced by circumstances who legitimately seek protection. And indeed, when one looks at the material coming from UNHCR at the same time, they were very keen to emphasise the inability of the Refugee Convention to provide enough protection for the needs of asylum seekers. So, for example, in paragraph 8 on page 8 of my notes, UNHCR say, it's generally been acknowledged that however properly the refugee definition contained in the Convention and Protocol may be applied, there are some categories of persons in need of protection who do not fall under the strict scope of these instruments. Such refugees of concern to UNHCR include, for example, those fleeing the indiscriminate effects of violence arising in situations of armed conflict, with no specific element of persecution. And there are many other statements by UNHCR and indeed the European Commission of similar force. So, we can certainly see that in terms of achieving this fundamental objective of an area of freedom, security and justice, there are strong grounds for taking a broad, expansive approach. Something which you might say is inconsistent with the Home Office proposition, because Article 15C is no more than a particular example of the traditional ambit of the European Convention on Human Rights, but in wartime. When I was researching this, I was instructed on test cases in the tribunal a couple of weeks on this issue, in the context, not surprisingly, of Iraq, the most controversial cases coming out of the appeal tribunal probably for a decade. And it's quite interesting to look at how effective British law has recently been in dealing with, usually, forced migrants. Because one way of assessing whether or not the right people are getting protection in terms of international protection is to see who is getting emergency support. And under Section 4 of, I think it's probably the 99 Immigration Act, there are certain provisions called hard cases support. And the hard cases support provisions are designed for people who've fallen through the net of refugee convention protection. They're basically facing expulsion from the United Kingdom. People who, in theory, are bogus asylum seekers, as the newspapers would call them. And you might expect those people to be either liars, or people whose protection claim is found to be false, or people from countries which have got better in recent years. Neither of those labels would sit easily with what the newsreels tell you with what's going on in Iraq. And yet, if you look at the statistics at the moment, I was in paragraph 37 of my notes, by far and away, in late 2007, the biggest source of applications for hard cases support was Iraqis. Failed asylum seekers, bogus asylum seekers. 3,225 applications in only 3 months. So strangely, at the end of the status determination system in the United Kingdom, supposedly detecting those in need and those not in need of international protection, it's primarily Iraqis, who were being identified by the